video there, please.
Okay, we are on YouTube. Not on record yet. We are on audio YouTube. You want it off?
Huh?
Audio YouTube's on. Do you want it off?
No.
Okay. Not on the court record yet. Okay.
Okay, there at the jail, Mr. Hausman, definitely need to reactivate the video there and shut off. There you go, thank you. I had a little technical difficulty here this morning. Still on.
Oh, you ready to go?
Yeah.
Okay.
All right, this case number 21 CR 110, State of Ohio versus Ronald D. Hausman II. You're Ronald D. Hausman II.
Yes, sir.
All right, then this is hearing is being conducted by Zoom. Hausman is appearing from the jail. His attorney is William Armentrout, and the Westland State is advocating they're both appearing by Zoom in their offices. The defendant have been referred for a further evaluation after the last hearing, and the Twin Valley had reported back that he was restored to competency. The court went ahead and ordered the evaluation for the mental state at the time, and each of the attorneys received a copy of that. Mr. Armentrout, Mr. Candy. Okay.
Hey, how's it going?
All right. Well, the court doesn't need to do anything in that. That was just the purpose to determine whether or not there might be support for an insanity plea, and that reported case there is not. And so we'll go ahead and restore this to the active docket. And don't know that we've had any pre-trials on this, have we?
No, we have not, Your Honor.
Okay. All right, so we'll set our first pre-trial for March the 16th at 1 o'clock. Final pre-trial will be April 7th. At 1 o'clock. Trial will be April 25 at 8 a.m. And the time is told to the new trial date.
Your Honor, if I may, maybe we can just go to the final pre-trial now. Myself and the state are very, very disappointed.
Okay.
I'm in actually Springdale Court on March 16th in the afternoon.
Okay. Actually, it's March 17th anyway. Sorry about that. 1 o'clock. So let's just make that the final pre-trial, and then we move the trial date then up to March 24th. Oh no, that's too soon. April 11th. All right, with your calendar.
I would say, I was already scheduled that day.
Well, yeah, I think I have you already scheduled here. Okay, that's what we'll do then. All right. Thank you. Do we have a separate Zoom site for 1 o'clock?
No, they're all the same, I believe.
Okay, all right. So I don't know. We've had one sentencing from the jail, I think, on Zoom. So in person. One I think that we sent for Zoom for some reason. Oh, no, maybe that's the one that was set down in Galley County.
That's not.
Jeremy Bicker's in Clark County Jail for sentencing.
That's Denny at 10.
Huh?
That's Denny at Josh Coleman. Galley County guy.
Yeah, well, we just got a call. They can't do it today.
Because I thought it was me. I got the notice. I'm like, that's not me. So I looked it up. That's the only reason I did.
Yeah, yeah.
Jeremy Bender, Adam said, is in Clark County Jail.
Clark County? Is that what you said, Adam?
Clark County, Highland County.
Oh.
Okay, yeah, all right. And who's his attorney?
Danny.
Denny.
Okay. And we have that one set by Zoom, I believe.
Correct, 9 o'clock Zoom.
Okay, so we'll do that one, then, do the others that are in person.
Okay.
Alright, thank you. I'll just leave this, going on then.
Okay, I'll go grab it.
Thank you. Okay. Is that, probably won't be for about another 7 or 8 minutes. 10 minutes, actually.
My Mr. Ford is running behind, he called.
Who is?
Mr. Ford.
On the record for Bender, Your Honor.
Recording in progress.
All right, this is State versus Jeremy Bender. We have two cases, case number 20 CR 81 and 21 CR 167. Are you Jeremy and Bender prepared in the jail? Well, they're going to need it. All right, this case number 20 CR 81 and 21 CR 167, State of Ohio versus Jeremy Bender. P. Bender, are you Jeremy P. Bender appearing there from the jail?
Yes, sir. Good morning, Your Honor.
Morning. All right. This is sentencing in these two cases. This hearing is being conducted by Zoom. Defendant's attorney is Dennis Kirk. He is appearing from his office, representing the state. Assistant Prosecutor King appearing from his office. Mr. Kirk, are you and your client both agreeable to this hearing being conducted by Zoom rather than in person?
Yes, Your Honor.
And you're all right with that, Mr. Bender? All right. In case number 20 CR 81, the defendant entered plea of guilty to aggravated possession of methamphetamine, a 5th-degree felony. In case number 21 CR 167, entered plea of guilty to failure to appear. The court ordered a pre-sentence report, which I have received, and I've reviewed. I believe the attorneys received a summary of that. All right. Mr. King, on behalf of the state.
Thank you, Your Honor. The state is requesting that the defendant be sentenced to a term of incarceration. Looking at this defendant's track record, he has multiple opportunities academically for the past. He was failed each time. In 2009, he was placed on community control of this court. 1 year later, he violated the condition of his sentence to prison. More recently, in 2017, he was placed on community control of Ross County with a felony 5 receiving stolen property. After 3 community control violations, they finally gave up, terminating him unsuccessfully. And looking at the cases that are before the court today, the initial case, the CR 81 case, this defendant was arraigned on August 13, 2021. So 2 weeks later, on September 1st, he got to appear. I don't think there's any reason to believe that he can file requirements of the court. So, based on the defendant's record, and also his disregard for the court and the recent laws, the state would ask that he be sentenced to termination. Thank you.
All right, Mr. Kirk.
Thank you, Your Honor. I do recognize that in this case, my client has struggled at times. In this particular case, obviously started out as an F5 and very good here. Really speaking, I think that there's been some successes in the past with CBCFs. He went to STAR in the past, and then back in 2009, completed it successfully. And also, I think had some time at Outlets and Hospice and aftercare after that. Would ask the court to consider community control to check the probation department. There's a bed date available to STAR on March 16th of this year. Believe that STAR program would be a fitting program for him. Most cases we're dealing with substance abuse. However, in this case, the original charges were aggravated possession of meth, but it appears my client's been sober for about a year now and does not necessarily qualify for residential treatment. But I think STAR would be a good place to give him one last chance to straighten, out some of these issues. And I've talked with him, and he does acknowledge his mistakes that he's made, and is asking for some sort of programming around the prison in this particular case. So would hope the court would consider the STAR program as an outcome as opposed to prison. Thank you, Your Honor.
All right, Mr. Bender, anything you would like to say?
I know it worked well on me in the past. However, I have learned every experience that I've been through. I've completed all the programming I've ever been set forth. My issue is this. I have an indefinite alcohol suspension of my license. Transportation is really hard. To have somebody else take me to and from, and it's like putting them in my shoes for undeserving reason. this indefinite suspension can be lifted off my license upon completion of a 6-month inpatient program. Once I complete the 6-month inpatient program, I monitor for 6 months after this, and this indefinite suspension goes away. I went to college for automotive, and to obtain a job in my field of study, a driver's license is very necessary. I've never dropped dirty for any substances or anything for the programming or probation. My issue was merely getting to and from. After speaking with substance abuse probation yesterday, she informed me that they have FRS transportation. They have programs and outpatient programs for helping me get my license back. Getting me to and from to report to probation is the only issue I've ever had. Because cooperation with community control, it wouldn't be an issue. I never had the opportunity with help to get me to and from. On top of this, my mother is extremely ill. When I went to prison last time, I lost several family members, including my grandma who raised me. My mother has had partial amputation of her leg. She is not well, and there's supposed to be an impact statement from my mother and an impact statement from Brightview and outpatient programming that I've previously been able to set up. I just, my dad just passed away last year, around August, and that's why I was in work. I'm losing my family left and right. Not being there is, it's pretty harsh punishment on myself. It's pretty hard on myself. I got 2 daughters that they're hitting milestone 30 days. I got my 15-year-old's turning 16. I'm not going to be there. My 17-year-old's turning 18. I'm not going to be there. I got a 9-year-old daughter that needs me. I can't get to her. Driving is my issue. I don't have a license. I've been clean off of alcohol for 5 years. I've been clean off of drugs for 1 year and 2 months. I don't qualify for the inpatient rehab because I got over 1 year clean. The Massey House rehab is 10 miles away from my mom. I respect you, Mr. Cross. I would walk away from a program on you. I don't have intention of doing such things. I've been clean 1 year and 2 months, but I didn't make it out without getting in trouble. This case is 2 years old. Being clean is long. If they don't qualify me for a rehab like Massey House, which is what I need to get my license back. I grew up wrestling here in Hillsborough. Mr. Parr knows me very well. I wrestled on his wrestling team. I respect Mr. Parr very much. And yes, I did complete the program back in 2008 and 9. After that, when I was released, I got out. I went to Miss Carrie Martin, and I told her that everybody I know and love is heroin. So I volunteered to go to the Alice House, and I completed the Alice House. After this, I went and stayed with my dad, who was a pretty heavy drug user, and I ended up, I didn't drop dirty, but I missed reporting in probation, and yes, I did. One violation got me my career state to the Ross County Community Control. I didn't go to prison. I just had trouble working full time Johnson Control and getting to reporting. Missing reporting got me jail time. Every time he violated me, I went, I did what he asked, and they released me. To be London, and to be a year and 2 months sober, it's bittersweet because I didn't make it out without a drug charge. This is my first drug charge and the only drug charge on my record. However, the alcohol, I've been 5 years sober off of alcohol, which was my serious problem. I have 3 DUIs on my record. That's been more than 16 years ago. I want a chance to do a master house rehab, which is what the DSD calls for, is for me to do an inpatient rehab and then be monitored. Mr. Carr would be more than willing to help me work through this. I'm not a bad person, Mr. Cross. I'm a good dad. My daughters really want to see me do something great with my life because I am that good of a person. I don't go around hurting people. I don't. I'm a good person, Mr. Crow. So, I really am a good person. And I'm working on being the best me I can be.
All right. Well, looking back at your record, I actually see that in 2008 you had a drug paraphernalia conviction. Might be your first felony drug offense, but you do have that. The report makes a very, very significant note, and that is that you have a history of completing court order treatment, but no history of successfully completing community control supervision, which is the case. Your time, you spoke at length. Now your time is done. Okay. Now I'm speaking, and you be quiet. Now, according to the report, you told them that the last time you used meth was in February 2021, which is just a little over a year ago. And we really don't have any way of confirming or telling us that you were drug-free for whatever period of time you claimed, because you weren't in any kind of treatment, you weren't being tested, you weren't reporting being tested, so that can be confirmed. You've never done well on community control. Back in 2010, after you got out of STAR, you were revoked and sent to prison for a third-degree felony. Then in Ross County, you had 3 separate violations before they finally they gave up on you. And what they did is they terminated you unsuccessfully. They didn't send you to prison. They just said, we're done, we can't do anything with it. So you got rewarded for not complying because they didn't make you go to prison. You did 34 days originally in jail, and then another 78 days total on a felony, and didn't do what you're supposed to do. And so, transportation, I understand, can be an issue, but it doesn't seem to affect your ability to get drugs, at least in this in the 2081 case. And you failed to appear in September of 2020, I believe, or no, September 2021, and they had to go out and find you, and you didn't make any calls. If you have a transportation issue, you also have a phone. You can call. You can always tell a call information. FRS has been around for a good while. So, once you're very eloquent and you're talk, but actions is what matters. and not the top. And so, based on the fact, and then you completed programs for drug treatment, but yet you still picked up this drug charge, even after you completed 3 different programs. So the court is of the opinion that the drugs is not your, and treatment is not your issue, it's just your behavior, that you are non-compliant and continue to not comply. So it's the order of the court as to case number 20 CR 81 that you be sentenced to a term of 8 months, and you have, according to the sheriff's certificate, 103 days of credit for that, 8/21 to 8/13, 21, and 11/22, March 2nd. All the time you've been in jail since you were arrested has been credited to that case. In the failure to appear, you're sentenced to a term of 10 months. There's no jail time credit on that, because I would think your other sentence. These sentences were to be served consecutively to each other, because the second offense was committed while you were free on bond on the first offense, and the harm is such that one single prison term not accurately reflect the seriousness of the behavior, and the sentences are not been proportionate to the seriousness of the offense. Also, the history of criminal conduct and your behavior during control indicates that consecutive sentences are necessary to protect the public. So that would be the judgment of the court. It would be held in custody until you're conveyed to the institution. Now, upon completion of this prison term, it is possible the adult parole authority, at their option, will put you under post-release control for a period of up to 2 years. They don't have to, but they can. And if they do, then you'll be supervised in the terms they set, and then during that period of time, they determine that you have failed to apply, they can return you to prison, make you serve an additional period of up to 9 months for one violation. But in this case, that's also the cap, half for all violations. However, if you committed a felony or you're under post-release control supervision, then in addition to whatever sentence the judge in the new case imposed upon you, that judge can also authorize a sentence in this case for committing that offense while under post-release control supervision, in this case, an additional period of 1 year, whatever time is left on the post-release control period, whichever greater that occurs, that must be served consecutively the sentence in the case. There'll be no fine, no driving suspension in the 20 CR case, the 20 CR 81 case. You are ordered to pay the court costs, which has a grant execution order. If you fail to do that, then the court can collect that through various means, including letting on bank accounts, wages, earnings, or other assets that you may have. If that doesn't collect it, then upon completion of the prison term, the court could allow you to do community service in this county and give you credit for each area of work, reduce your judgment by that amount. Okay. All right, is there anything further, counsel? All right. Okay, you're remaining in custody, Mr. Bender, and we'll see you over here in a couple of minutes, Mr. King.
Yes, sir.
Is there any chance of possibly technology?
Okay. See, Mr. Wagner, where did you get him into this tomorrow? Prosecutor, yes, sir. Yep. Mr. King's on his way.
What are you doing first?
Yes, sir.
Is this Mr. Mock first?
Yeah, and we'll wait for after.
Okay.
Case number 21CR131, Stable House versus Brian and Mott. Present on behalf of the state is Assistant Prosecutor King. Present on behalf of the defendant is James Wagner, and our new Brian A. Mott.
Yes, Your Honor.
And Mott. Mr. Mott is under the ability to have weapon under disability, third-degree felony, and forfeiture by specification. The court ordered a pre-sentence investigation. The court has received that review the same week the attorney received the summary.
Yeah, so, well, no, Your Honor, I have not, I think I came in and asked for it today, I think my copy's already been finished.
Oh, we'll see it?
Yes. Can I approach, sir?
Yes.
Thank you, Your Honor. I'm fine, sir.
All right. Mr. King, anything on behalf of the state?
Only was to get the agreement, Your Honor.
You want to report to the sheriff department?
Yes, Your Honor.
Or, Wagner?
Yes, sir, Your Honor, thank you. Your Honor, we would ask the, excuse me, the court to follow the recommendation of the parties. I'm sure the court's already been presented with it. Mr. was gracious enough to give me a copy of the star referral. I'm sure the court's going to look at Brian's PSI, arguably, I mean, disrespectfully, raising eyebrows, saying, how we think of Brian. I'm asking the court to do that, Your Honor. I would say Brian is a very, I mean, respectfully, Brian, interesting individual. If you look at his outer appearance, I don't mean this mean with tattoos, you kind of know what kind of guy we're dealing with. I can say from the beginning of this case, Your Honor, it's kind of drug on for a while. For various reasons. When I first met Brian, he was combative, defensive, almost bucking authority. As I got to know him and he had time in the Justice Center, it was almost as if whatever drugs he was using or mindset he had flown or gone out of his system. Then he was out for some time. I think maybe he got back into some issues and got detained again. Did the mental eval. Then Dr. Dreyer reached out to me one night, Your Honor, and spoke to me on the phone. And she almost held the same opinion that what Brian's issues are the substance abuse. And she told me, in paraphrasing, you know, he gets back on this stuff again. I don't know mentally what will happen to him. He may not come back from it. But since then, since Brian's been out, he stays in constant contact with me from all things that at least I haven't had any reports that he's not been compliant. He's very articulate. When we spoke, he told me about what he hoped his future would have been, but he didn't talk about that that's in the past. He still is talking about what he wants to achieve after from here. And I think, again, not to reiterate, is once you get to meet Brian, you get past the tattoos and maybe some of the appearance that may offend some people, he actually is interesting. He's very bright. I mean, if he takes advantage of this situation, if it's granted to him, I think he could succeed. He's always supported by his grandmother. She's here somewhere. And I don't have any valid proof of, you know, again, I've got to meet both of them. He's had a rough childhood. Some things happen to him that we see in this court that shouldn't happen to any child. And I think that may have been the issue with Brian. But, Your Honor, we're asking the court to take this leap of faith. I think he can do it. I've explained to him it's going to be more about behavior modification and substance abuse. And he was exactly what he was asking for, Your Honor. So we're just asking the court for this opportunity.
Hey, Mr. Monk, anything you'd like to say?
I really appreciate the opportunity, John. And I'm just striving to become better now. I'm just struggling with some things that are personal. And I will not let the court down. It's great opportunity to move forward. And I appreciate that. That's all.
Well, you and your pre-sentence report, I noticed that when they were asking about where you got the gun, and you said that, they left there by a friend, didn't want to tell him who that was. They asked him if he knew he and Dan Berry, the owner of the gun, and he said he did, and then he sold it to his friend, which isn't true because it had been reported stolen. And he didn't give any information about how he came into possession of the gun. In your pre-sentence interview, you told the PSI officer your written statement was weapons under disability, self-defense. I'm not happy with it. I'm looking at your record, and you started off as a juvenile in a big way. Aggravated burglary, felonious assault, aggravated robbery, attempted burglary, commitment to DYS. Then as an adult, you have a previous weapon under disability out of Claremont County in 2017, same offense you are here. 4 years community control, revoked, sentenced to prison. And then conviction for possession of heroin in Claremont County in 2018, along with illegal conveyance of particular items, which probably was the heroin. And so we've had, then you have possession of heroin out of this county, where I gave you community control back in May 18th, 2017, and we were revoked on 6/22/18. And then here we are. You got out of prison. I'm not exactly sure when, but here we are again with weapons in your possession. Even with the fact that you know you're not supposed to have weapons, and you've previously been convicted for having weapons, you still have weapons. You get them again. And what in the court's view is that there are people who commit crimes because they have substance abuse issues, and then there are criminals who have substance abuse issues. And I think you're the latter. You just seem to be, in my opinion, based on the evidence, a dangerous person. And I'm very concerned that it's just a matter of time before you get, because it appears to me that you will not pay any attention to the law or go get weapons. And at some point in time, somebody is going to be harmed because of your proclivity to do that. And so the court feels that it's necessary to protect the public by sentencing to prison. And if the order of the court that should be hereby sentenced to the Correctional Section Center in Orient, Ohio, for a period of 24 months. You'll be given credit for 54 days and jail time credit. Upon completion of that sentence, the Self-Control Authority may choose to exercise options under police control. I sincerely hope they do. Again, I believe that's necessary to protect the public. And if they do, you'll be supervised on the terms they set, and if during that period of time they determine that you have failed to comply, they will be entitled to return you to prison, making sure an additional period of up to 9 months for one violation, up to a maximum of half a prison term for all violations. However, community felony, while you're in post-release control supervision for this case, then in addition, whatever sentence the judge in the case imposed upon you, that judge is also authorized to sentence in this case, an additional period of 1 year, whatever time left upon that 3 years of post-release control, whichever is greater, that occurs, and after certain consecutively sentenced in the case. You also order pay the court clause for judge to grant execution order. If you fail to do that, the clerk can collect that through various means, including levy on bank accounts, wages, earnings, or other assets that you may have. If that doesn't collect it, then the court can have you do service and do credit for each hour you work in and out of the way set with the court, but it has to be discounted. And each hour you work to reduce your judge by that amount. All right, so anything further, counsel? Your remaining discussion, Austin.
You step back to Lieutenant Brown, please.
Case number 21, CR 129, State of Ohio versus Jeremy Charles Curran. Served on behalf of the state, the prosecuting attorney King. Served on behalf of the defendant's attorney Dennis Burton. Are you here, Burton?
Yes, sir.
All right, Mr. Burton, entered plea guilty to receiving stolen property, a fourth degree felony. Matter was referred to the probation department for a pre-sentence investigation. Court has reviewed that, and each of the attorneys may receive a summary.
Yeah.
We have your own. All right, Mr. King, on behalf of the state.
Thank you, Your Honor. The state is requesting that this defendant be sentenced to a term of incarceration. We'll start by noting that this defendant is currently under PRC, committed discipline while he was under post-release control supervision. Also, this defendant has an extensive criminal history. Looks to me like he has, I think, 4 prior numbers, 11 prior felony convictions in multiple counties in Ohio, felony convictions from the state of Florida. And also, this defendant was recently given an opportunity by APA to try to get back on track. He was sent to a CBCF in Lebanon. He was ordered to complete that in 2020. He lasted there for a grand total of 16 days before he was violated. I think that's very telling. The defendant's criminal history, his conduct on the PRC, shows that putting this defendant under immediate control would be a waste of time and resources. So based on that, the state would ask that he be sentenced to a term of incarceration. Thank you.
Sure.
Thank you, Your Honor. My client is currently at the Phoenix Center. I do have a letter of verification that he continued as of yesterday that he does continue to be a participant in the program. I know the court is aware that there was an issue here about a week or 2 ago where my client did leave for about a day or 2 from the center and that actually did return. It appears that the Adult Parole Authority is in support of him remaining at the Phoenix Center or at a comparable program rather than prison in this case. And speaking with my client, he and looking at his PSI, he has struggled with substance abuse for a very long time. Looks like from his teenage years forward, lots of different substances, and it's been a big struggle for him. And in this particular case, this serious addiction has led to in and out of treatment, and that's why I think the one treatment did not work where he was there for about 16 days. My client currently has a STAR bed available according to the probation department on March 16, 2022. And then with his risk assessment, I'm sure, I don't know exactly what all goes into a risk assessment, but I'm sure that looking at the PSI, there's a high risk here. And so I think he would be a good candidate for drug court as well. I've discussed that with him and what that might mean, and he's expressed an interest in that as well. So would ask the court to consider community control. I know that there are a lot of prior felony convictions. I believe the last one was in February, or was in 2013. So there has been a slight gap there before these charges. And he could have walked away from the Phoenix Center and stayed away, and he did not. He chose to return. And again, I think that all paroles in support of this as well. Thank you.
Do you like to say, Mr. Recorder?
Yes, sir. After talking to therapists and starting mental health treatment at the Phoenix Center for the first time, I'm starting to get pretty much leveled out as far as being in the free world. I've never accepted help before. I've had every opportunity, but I've wasted it. And I'd really like a chance to at least finish this treatment at the Phoenix Center. I'm dealing with a lot of their therapists and counselors. I'm doing great there. I sent a letter of $20 to secure my things just in case the worst happened here today, and notified my parole when I came back, and they allowed me back in to finish. I'd really like a chance to finish the program. It's a great place, and I've never given anybody really the opportunity to help me before. I feel like for the first time I'm kind of getting straightened out on mental health meds. I don't want to just end this with another stint in prison and then back to the same thing. I'm trying to break this cycle for the first time. I've lost much half my life in this prison system. My choices. I'd like to get it straightened around and around. Hopefully finally change it. I just really like an opportunity to finish this treatment, regardless of what happens here today. And sorry. additional time on the court's docket. That's all I have, sir.
Well, the pre-sentence report does indicate you have 11 previous felony convictions. The most recent one was an abduction. Violent offense. You were on post-release control because of that. You walked away from the treatment program and then went back. Certainly the motivation there was to stay out of prison. Not necessarily to get clean. And this is an offense where you stole someone else's car. And apparently there were some other vehicles that being investigated that didn't result in any charges being made. But the court feels that people go out and commit crimes around PRC, which are reserved for people that are the worst type of offenders, and commit crimes that hurt other people, such as this one where you stole somebody's car, that there has to be accountability for that. And given the circumstances, it's a court finding that control is not appropriate in this case, and therefore it's a general court that should be hereby sentenced to the Correction Reception Center at Ohio for a period of 8 months. And according to the sheriff's certificate, you have 6 days of jail time credit. You have PRC time, which as of August the 6th, August the 6th, was 431 days. And that's been 6 months ago, so that would be less than 365 days remaining. So therefore, under the law, 1 year is the sentence being imposed because it's 1 year or whatever time's left, whichever the greater. So court orders that you be sentenced to a period of 1 year in addition for committing this offense while under post-release control. That is ordered to be served consecutively as required by law. You're also ordered to pay the court costs for judgment and executed orders. If you fail to do that, clerk can collect that for various means, including one bank account where you're earning other assets you may have. If that doesn't collect it, then the court clerk and the court can, after you get out of prison, allow you to service and give you credit for each hour you work in and out of arrest, settle for each hour you work, reduce your judgment by that amount. Now, upon completion of the sentence, it is possible that the adult parole authority will place you under what's called post-release control supervision for a period of up to 2 years. It's optional, not mandatory as it was in your abduction case. They do that, as you know, you'll be supervised by a parole officer, and if they determine that you have failed to comply and you're appearing in prison, they you serve an additional period of up to 9 months for one violation of the half of your prison term for all violations. But if you're committed a felony while under post-release control supervision as per here, then in addition, whatever sentence the judge in the new case imposed upon you, that judge may also sentence you to an additional period of 1 year, whatever time is left on that period of post-release control is greater. That occurs, then has to serve consecutively the sentence again. Written restitution.
That's what I was just going to say. The victim had a $250 deductible, so the restitution would be $250 to Joyce Gaster.
Court orders that the defendant pay $250 to the victim, payable to the victim restitution escrow account, pay any service fee according with that. That is a subsequent order, Mr. Perlin, so even though you serve your entire prison term, it'll still be there and it can't be discharged in bankruptcy. And you could be subject to further incarceration for contempt if you have the ability to pay it. Refuse to do so. All right, any further? Thank you. Thanks for man in custody.
Step back to Lieutenant Brown, please.
Madam Clerk, Your Honor, I have a couple entries.
Yeah.
Thanks, sir.
We're back to Captain. Others at dinner at the end, you can run there for Pleas, or you won't have to go in Pike's Bay. Case number 21, case number 21 CR 192, State of Ohio versus Rebecca L. Cap. Attorney on behalf of the state is Assistant Prosecutor Attorney King. Attorney on behalf of the defendant is Attorney Dennis Kirk. And are you Rebecca Cap?
Yes.
And this captain is under plea of guilty to evidence, first-degree felony. The court ordered a pre-sentence investigation. The court had reviewed that, and the attorneys reviewed something in that case.
I have, Your Honor.
All right. You're King, half the state.
Thank you, Your Honor. The state is requesting the defendant be sentenced to a term of incarceration. I realize this defendant has no criminal history whatsoever. However, as far as the state is concerned, what she did here is truly despicable. The court is obviously aware of the case involving John Smith. He was sentenced last week by this court to a term of 10 years to life for the rape of his step-granddaughter. That would be the defendant's stepdaughter. Once the investigation into the sexual abuse was underway, John Smith went to his daughter, the defendant, disclosed what he had done, and also disclosed that he had taken photos during the sexual abuse. Those photos were on the defendant's phone. After being armed with that knowledge, the defendant, instead of taking steps to protect her stepdaughter, took steps to protect the abuser. She deleted the photos from John Smith's phone, and then obtained a new phone from Mr. Smith. So, she obtained a new phone for him, yes. So, based upon that, and just the despicable nature of what the defendant did here, the state would request that she be sentenced to a term of incarceration. Thank you.
And this was reported by the father?
This was reported by the father. That's correct, Your Honor.
All right, Mr. Kirk.
Thank you, Your Honor. Unfortunately, this is a very unfortunate case. The only positive I can find out is that this would never have come to light. My client would not have told not have told the father of the victim. She found out and did share that information with the father's victim. So had she not done that, we probably wouldn't have had any charges on Mr. Smith, at least not maybe in the capacity they ended up being. She did admit wrong. She admitted to law enforcement. She's admitted to the court by pleading guilty. That she did delete a photo. I'm not sure that it was more than one, but I know that it was just
one or two at best. And it's a very despicable thing to do, obviously, but she did make the case come to light. She has cooperated, she did confess, and in this case, she does have several medical problems, and she also has some mental health issues, which I believe led to the commission of the offense, which she does receive treatment for at Behavioral Health Services in Amelia, Ohio. She has no prior record. Her PSI was one of the most brief that I've seen in quite some time. I'm not sure that it even encompassed the full page. She does suffer from, as I noted, several mental health issues, and no prior, not even a speeding ticket on her record, and a very poor lapse of judgment in this case, and she's admitted to that, and would ask the court to impose community control. There's nothing to say that that would not protect the public and also punish my client appropriately with the sanction of community control. This is a mid-level felony, so there's no mandatory prison, and so this seems to be a case where, given her record and given the overall circumstances, the community control would be appropriate. She would be amenable to that. Thank you.
Captain, anything you'd like to say?
Yes, Your Honor. When I found out what had happened, my father had only admitted to me that he had propositioned my daughter for a blowjob. And as soon as he had told me this, I packed my daughter's things and my husband's, and I moved them to my husband's mother's. And when my father came to me and asked me about the picture, and I took a picture and I deleted it so that you couldn't see it, but it was still on the phone. And I knew that, so that I knew that the cops were going to be able to get us. But I didn't want him to happen to me. He could do it for me and things like that. I thought I was doing the motherly thing. I would never intentionally hurt my baby girl. I've known her since she was 2 years old. Your Honor, this little girl had a rough start. Her mother allowed her to be her biological mother. And I thought I was protecting her from the monsters. I didn't know that I was living with one. And I know that they brought up the fact that I bought him a new phone, but I didn't have any money. And I bought my whole family a new phone. My daughter, my husband, myself, my mom. Because we were all playing about crazy. It just happened at a really bad time. I know what I did was wrong. And you never know what you're going to do in that situation. But I thought I was doing the mother thing, taking the picture away from him. And I'm sorry to my daughter, because now she's been with her uncle. She barely even knows. I can't have contact with her or anything. And I didn't know everything that he had done until after I went to jail. And I read his confession. And I'm sorry, but I hope he suffers for what he did. I truly am sorry. And I regret what I did. If I could, I would have taken the phone straight to the cops. I know that now.
The team was not victim impact data submitted by the father.
No, Your Honor. the child was between the ages of 6 and 9 when the abuse occurred.
Alright, anything further?
No, Your Honor.
Judge, the victim's father didn't fill out a victim impact statement, but I've spoken with him on the phone multiple times.
I just wondered if he had a statement.
Do you want to hear what his feelings are and that? Okay.
All right. Well, Captain, really troubled by the details of this offense. All indications you've been a good, law-abiding citizen. But in this case, what you did, I think you're trying to put the best spin on it as possible. Maybe you actually believe it, it's sad if you do, because your father, in his statement, said that when he showed you the photograph, told you didn't want to go to jail, that you agreed and just made a mistake, didn't deserve any jail time, and so you deleted the photos for it. Not only did you delete photos, but then you also bought another photo, or got another photo. You didn't call law enforcement, you didn't report it, apparently you did tell your husband, and again, that's just your stepdaughter, understand it. And not for several days, because law enforcement wasn't contacted, I think, until a week or so later, according to what I've read in the, he contacted law enforcement on September 21st, and the indictment was September 15th through October 19th. And initially, he, well, some of his statements were of questionable concern, I think, to the investigators, and those pictures would have certainly been extremely relevant, and may have had, you know, could potentially have affected what the charges were. Child abuse, sexual abuse is the most despicable crime that there is, short of murder. And actually, in many cases, worse, because these children that are harmed, they bear these problems with them forever. And when an adult finds out about it, they have an obligation to protect that child, particularly when they're the stepmother, or you call her your daughter. So you didn't do that. You didn't. You chose to try to protect your father. I believe that's what your aim was, not to deprive him of looking at the picture, but to keep him out of jail. So you chose loyalty to your father over the welfare of a young child. And that is something that cannot be ignored. There has to be accountability for that, because it's too often, unfortunately, family members, mothers, fathers, cover up child abuse. And a lot of it goes undetected because of that. And so there needs to be a message sent to people that if you help the child abuser, whether it's in committing the offense or in trying to avoid being held accountable for that, there has to be accountability. So it is a judgment order of the court that should be hereby sentenced to the Ohio State Court for Women at Marysville, Ohio, for a period of 12 months. You'll be given credit, according to the sheriff's certificate, of 3 days jail time credit. Now, upon completion of this offense, it is possible it should be put under post-release control supervision by the adult control authority. It's not mandatory, but they'll make that decision. And if they do, you'll be supervised on the terms they set by parole officer. And if they determine that you fail to comply, then they could return you to prison, even though you serve the entire prison term set by the court, for a period of up to 6 months for one or more violations. But if you're going to do felony under post-release control, then in addition, we have a sentencing judge in the new case with both counties. That judge is also authorized to sentence in this case for an additional period of 1 year. whatever time's left on that, so this is control service agreement. I'd be glad to state that the period of time could be up to 2 years. And whatever they decide. And if that occurs, then whatever the sentence is, whether it's 1 year or more, depending on how much time left, that will be served consecutively the sentence in the case. And also order to pay the court costs, which has a grant execution order. If you have to do that, then the order could already use their service, get a credit for each hour you work, and then I know there's that other court each hour you work, you should justify the amount of pay. All right, is there anything for the council? Remain discussion, yes. Okay.
May we approach your honor?
Yes.
One moment, Your Honor.
Case number 21 CR 175, State of Ohio versus Michael Shane Riley. Attorney on behalf of the state is Assistant Prosecutor King. Attorney on behalf of Tenants, Attorney William Armentrout. Are you Michael Shane Riley?
Yes, Your Honor.
Right, the defendant has entered plea of guilty to receiving stolen property, a 4-3 felony. Court ordered a pre-sentence report. I have reviewed that, and the attorneys received the summary.
Yes, Your Honor.
All right. Anything on behalf of the state?
Thank you, Your Honor. The state would ask that the court follow the plea agreement and place the defendant on community control. The total amount of restitution in this case is $2,080.57. That would be paid to Stephen Williams. That comes from repairs that were required to the Kubota after it was recovered, and also the tow bill that was paid by Mr. Williams. Thank you, Your Honor.
Strong count.
We agree with the restitution, Your Honor. Your Honor, we'd ask the court to follow the recommendation of the state and place Stride on community control. Obviously, I was aware of the prior number of convictions due to discovery before we got it today, and normally it'd be hard to argue with community control with a straight face, but the state has recommended it. With respect to his prior felony convictions, 22 I think it is actually, it appears that he successfully completed several post-release controls. There was one with like an unsuccessful discharge. I don't know if that was a misdemeanor or a felony. And in this matter, and I know I wouldn't expect the state to agree with me, but and this is me talking, not my client, we felt the case was very defendable. The day the cops showed up, I think the Kubota or whatever it was in plain view. He in fact found the bin for them. Cops asked him if they could look around without a warrant. Let them look around. In fact, they came back another time without a warrant. And, he welcomed them to look wherever they wanted to. Nothing came of that. So we're asking the court, in spite of his record, place him on community control, follow the recommendation. I believe that he can successfully complete it. We've agreed to the restitution amount. I had a printout from Mr. King, it was actually $1,800 something. I don't know what's, apparently there's a few extra items, I'm not sure what that was, but we're not going to dispute that. We're just not going to dispute it, Your Honor. So, that being said, we would ask you to follow the recommendation, place him on community control.
All right, Mr. Riley, anything you'd like to say?
No, Your Honor.
Pardon me?
No, Your Honor.
I believe he had 22 felony convictions, is that correct?
Yes.
Or is it 23? I thought I counted 23, the probation part counted 22. Which is it? Or do you even know?
I don't know.
How many numbers you got?
No, Your Honor.
How many?
No.
9 numbers.
Took me a long time to learn, Your Honor.
Well, the most recent one was 2012. So, people just shy of 10 years ago. Since then, you've had mostly traffic offenses, although there's a bunch of those. Child support suspension, foundation protection order 2018, misdemeanor. You're not working in it, are you?
Not at this time, Your Honor. I took some time off.
I can't hear you, Mike.
Not at this time, Your Honor. I have hip problems, so I'm getting my hip taken care of.
What's got to be done there?
Right now they're just giving me pain shots in it. I'm not sure what the end result's going to be. I'm trying to get them to fix it instead of just keep giving me medicine for it.
Are you still on Suboxone?
Yes, Your Honor.
Or subutex, yes it is.
Yes, Your Honor.
And that's from clinical?
Yes, Your Honor. I've been in treatment for about 4 years
How are you gonna pay this money back? Get control.
now. I'm going to go back to work. I have to.
Figure, you are a mechanic, right?
I do tree work. I run a tree crew with my brother. I do odd jobs here and there, Your Honor. So
Sorry about
here and there, I do odd jobs and we make money from that as well. So I'll be able to pay it back.
the only time I can see where you were put on community control looks like there were 2. Oh, I can see now why there was only 22. You had one conviction that was for Pleas, the CCW. Okay. But you were put on community control in 2001 to be in Montgomery County. 5 years community control was revoked. 2 months later, you were sent to prison. saying something because, Montgomery County, you really have to be determined to go to prison for that offense. You get sent to prison from that, as your probation department.
I refuse to go to treatment.
Yeah, you had to do something. And then I see that, another time, in 2010, 10 years later, we picked up over double-digit felonies. He got in control for another BAE over 2010. That was administratively terminated on March 17, 2011. And I think that's because he picked up some more felony charges. And rather than revoke you, they just terminate you. They didn't make it official. Yeah, that doesn't happen here. If you commit a crime while you're under control, you got to be accountable. And that's another behavior of the Montgomery County Probation Department I want to revoke. I tell you, I did read the report, did cooperate, I can see that. Since the state's recommending this, I'm going to go against my better judgment. I'm going to grant you complete control. But I'm going to tell you right now, you are on a really short leash. And you better be compliant. And I mean, completely compliant.
Yes,
So it's for the court that you be sentenced to a term of 3 years of complete control under the supervision of the probation department at 1 Main Street to report to that. When and as they direct, be required to obey all laws, all jurisdictions, protect yourself at all time, and at all time. Must be truthful in all statements you make to them regarding questions that they ask you about your supervision or any statements you make to them. You must keep them informed of your residence, place, and employment all the time, and not change either without prior permission. Not leave the state of Ohio at any time without prior written permission. And not enter upon the grounds of any correctional facility. Or need to communicate with anyone as an inmate in any of those facilities without prior written permission. You're not permitted to purchase, possess, own, use, have under control any kind of firearm, ammunition, dangerous ordnance, weapons of any type. You are not to purchase, possess, use, or have under control any kind of a controlled substance, drug, abuse, CBD, oil, kratom, or any variant of analog of any controlled substance that has an effect similar to the controlled substance or drug abuse, nor any instrument, device, or thing that you may use to administer, prepare drugs for administration unless you have a lawful prescription. Any of those items, and if you do, you must provide a copy of that in 24 hours of your receipt to the probation department. You're to submit to drug testing when and as requested. Do not purchase, possess, use, or have under control any type of alcoholic beverage, nor may be present places with the sole meaning of soothing is otherwise lawful. Not to associate with anyone as a co-defendant in this case, or any other person that has a criminal record, member of the gang, or other criminal group, or any person that has a past with influence you commit criminal offense, to violate these conditions unless as approved in writing by your supervising officer. Also applies to any family members that fall within that definition, unless you live with them immediately before the commission of this offense. You may not act the date of disorder, marry, or establish cohabitation in common law marriage type of relationship with another person after commission. Must report any contact law enforcement or arrest, citation, conviction, or charge of violating law not later than the next business day after that occurs. Provide your supervising officer with financial information, records so your ability to pay any of your fees or costs and restitution can be reviewed. You're referred by the probation department for an evaluation or assessment for any type of treatment, therapy, training, or other educational program. You can submit to that, and that treatment indicated you will successfully complete that. Pay the court costs of this action within and make a payment arrangement to do that with the clerk. Serve 15 days in county jail beginning now. You'll be required to pay the restitution of $2,080.57 to Steve Williams through the victim witness escrow account, and pay any service fee associated with that. Now, by being placed on community control rather than being sent to prison, you're being consented to a search without a warrant of your residence, vehicles owned by you or used by you, and the property or places under your control where you're found at any time, any officer of the probation department. Now, in the event that if you fail to pay the court costs, there'd be a violation of community control, then the clerk can also collect that through various means, through the level of bank accounts, wages, or any other assets you may have. If that doesn't collect it, then the court could order you to service give you credit for each item work in an hourly rate set by the court. Each item work you should justify that amount until paid in full. Now, in the event that the probation department feels you're not complying with these community control conditions, and they will file written notice at the court, you'll be afforded the hearing, be entitled to have an attorney. The outcome of that hearing is that you fail to comply. Then the court can revoke your community control and sentence you to a prison term of 26 and 18 months, fine you $5,000. If that happens, once you complete the sentence ordered by the court, the adult full authority could, at their option, place you under police control supervision for a period of up to 2 years, under the terms and conditions they set. And if they do that, then again, they determine that you failed to comply, they can return you to prison, even though you served the entire prison term set by the court for a period of up to 1 half of whatever prison term is imposed for one or more violations. However, if you commit a new felony, then in addition to sentence the judge in new case imposed upon you, the judge will also sentence you in this case to an additional period of 1 year, whatever time left on that 3 years police control, whichever is greater. That occurs, that must be served consecutively the sentence. All right, is there anything further, counsel?
No, Your Honor.
Your remaining counsel.
Your Honor, may I speak? What is your name?
Your Honor, he was at my office yesterday and had the jaws all packaged. He had a list of 2 fold. When he's supposed to go back to the dentist? Report tomorrow, Your Honor, if he has to go to the dentist today. You have to go to the dentist today. Who's the dentist?
All right, I'll, okay, then, report Friday at 4 o'clock.
Thank you, Your Honor.
Thank you.
Okay.
He needs to wait till I fill out a sheet for him here.
Yeah, he's gonna give you an assignment notice and report. That would be,
6th or 4th?
March 4th, yeah.
Okay.
Okay. Officer Brown, I think, whenever you can, whenever you're ready.
Thank you.
Michael, to your. All right, this is case number 21 CR 179, State of Ohio versus Michael T. Orr. Present on behalf of the state is Assistant Prosecutor Attorney King, representing the defense attorney Jacob Wagner, and you are Michael T. Orr? Yes, sir. All right. Now, Mr. Orr has entered a plea of guilty to breaking and entering, and that is referred to the pre-sentence investigation. I have reviewed that report, and have each of the attorneys received a summary.
State that, Your Honor.
Defense counsel has, Your Honor.
Has the co-defendant's case been disclosed?
He is pled, he's currently waiting sentencing, I think sometime this month,
Well, good. Because when I was looking at this, I didn't realize the victim in this case is Gerald Dove Halpy. I didn't know this. I forgot his first name, Gerald. I know his was Dove. Mr. Halpy, I've known him for many years. He was on the school board when I was a prosecutor down in Morristown, and then he also built a barn for me, and actually about 2 years ago came in and reclad that and insulated it before the concrete floor. And so I just wanted to disclose that to see if that was any problem with either party. Mr. Wagner feels any issue there.
Your Honor, I don't, we're in a small community, I'm sure you rubbed elbows with half the alleged victims in this county. I'm confident the court will be impartial in this issue.
The reason I brought it up because it's happened a couple of years, and actually after my wife died, he and his wife sent me an arrangement. Actually, it's an dining table rate was a higher state team, so it's still there. So I kept after that. I knows my ability to love it. Anyway, if you feel that that's any problem, Mr. Orr, I would recuse myself and refer this to another judge.
No, sir.
You have any problem with that?
No, sir.
Okay. All right, anything from the state regarding sentencing?
The state will simply ask you to the court follow the plea agreement and sentence the defendant to community control, order that he successfully complete substance abuse treatment. The total amount of restitution in this case is $5,110.80. Thank you.
And that'd be joint several with Mr.
Joint
Richards?
several, yes.
Okay. All right, Mr. Wagner?
Well, we asked the court to follow a recommendation. And reading through the discovery, at least the narrative that I read, this was a case where if facts are true, my client drove the other individual to this location that stole these items. Once it was discovered that these items were stolen, my client may have been involved. Officers reached out to him and said, hey, you know what, I'm calling. He basically sang like a canary. Yes, I do. Yes, I did. I was the guy that drove him. Might think he in the camper you're at. Yeah, here's a few things. We come to us, sure, no problem. So, I mean, he admitted his culpability from the very beginning, Your Honor. In speaking with him today, this morning he called my office, told me he was running late. Mr. King and I have been talking about a restitution issue. And it's more me advocating than my client. That being, Your Honor, the restitution amount was $5,000. Mr. Houghton came up with that amount to get to replace the items that were stolen. The stolen items, maybe not all of them, but a vast majority were returned. Just arguing for my client, I was saying, hey, there should be a set-off. This doesn't seem equitable. I get the argument it wouldn't happen but for my client's conduct. But I brought that up to Michael, and he's like, well, if I got to pay it, I got to pay it. I'm not going to argue about that. So again, he's not being defiant. He's taking responsibility. We tried to do, and he said it was sent arguably to the court from Brightview. I'm not sure if the PO got it or not.
I haven't got it yet. Oh, wait a minute, there's something here. It said here he's going to be assessed at Claremont Recovery Center, Claremont County.
I mean, where'd you Brightview?
I went to Brightview in Claremont.
Claremont?
Yeah.
I've not got a copy. He said he called him twice to make sure the PO got it. The APA.
Well, not the APA County.
County, I'm sorry.
If they did, they didn't send it to me. I just, like I said, the only mention here, and the report is that he was going to be assessed at Claremont Recovery Center. Okay.
I think even when we potentially looked ahead of time, getting an assessment done, I didn't even know that he would qualify for a substance abuse issue. That's not my field. But again, my point being, Your Honor, he cooperated from the moment Detective Engel and the Sheriff's Department called him and helped recovery of these items. That's it, sir.
All right, Mr. Orr, anything you want to say?
I know what I did was wrong. I take responsibility for it. I greatly appreciate community control. I had the assessment done at Brightview, and they told me they weren't recommending further treatment, but I don't know why they didn't fax the papers. I give them the fax number twice.
When you see the probation department, you tell them.
Okay. Well, I apologize for taking the course time up going wrong.
All right, thank you. All right, you see, it's the order of judgment court that you be and are hereby sentenced to a term of 3 years of community control under the supervision of the Highland County Probation Department on the following terms. First, you are to obey all jurisdictions, conduct yourself in all line manner all the time. You must report when and as directed. You must be truthful in all statements you make to the probation department. Any answer you give to ask any questions about your community control. You're to keep them informed of your residence and place of employment at all times, and not change out without prior permission. You may not leave the state of Ohio at any time without prior permission. You may not enter upon the grounds of any correctional facility in any jurisdiction, or may communicate with or attempt to communicate with anyone who is an inmate in those facilities without prior written permission. You may not purchase, own, use, or have under control any kind of firearm, ammunition, dangerous orders, or weapons of any kind while you're under control. You're not permitted to purchase, possess, use, or have under your control any kind of controlled substance, drug abuse, CBD oil, kratom, or any variant or analog of any controlled substance or that has effects similar to controlled substances or drug abuse, nor any other instrument, device, or thing that may be used to administer those or prepare the administration unless you have a lawful prescription for both the devices as well as the substance. And if you do, you must provide a copy of that within 24 hours of receipt to your supervising officer. You're to submit a drug test and whether that is ordered by probation. You may not purchase, possess, use, or have control any alcoholic beverage, nor may be present in any places where they're sold, being consumed, even as otherwise lawful. Not to associate with anyone as a co-defendant in this case, nor any other person has a criminal record, member of a gang or other criminal group, or any other person has in the past or in the future, influence you to commit a violation of these conditions unless you have that proof in writing by a supervising officer. That also applies to any family members who might fall within that definition, unless you were living with them immediately before the commission of this offense. After the date of this order, you're not permitted to marry or establish cohabitation or common law marriage type relationship with another person without written permission. You must report any contact law enforcement or any arrest, citation, conviction, or other charge violating the law not later than the next business day. After that occurs, you provide your financial or supervising officer with financial information records to your ability to pay restitution fees for costs of your review. Now, if you're referred by the probation department for any evaluation, assessment, any type of treatment, therapy, counseling, training, educational program, etc., you'll submit to that. If there's a recommendation for program, you'll be required to enroll in and successfully complete that. You'll be required to pay the court costs and make payment arrangements to do that. I forgot, are you employed now?
Yes, sir.
Okay. Well, you'll make restitution payments through the victim witness office and monthly payments. And are you working full time?
No, not right now, just part time.
Okay. Well, we begin the monthly payments May 1. And, you're only on 3 years community control right now, but if you don't get it paid off, you're not going to get off paper and you'll bring it back in here because you have to apply and we'll have to extend it. I can make it up to 5 years. I don't like to do that. I'd rather take 3 years. And at that rate, 36 months, you're going to have to make, probably $150 a month or something like that payment. Now, your restitution is ordered $5,110.80 to the county jointly and severally with the co-defendant. What that means is that you're each responsible to each other for half of it, but you're each responsible for the full amount at the end. Because the law says victims shouldn't have to chase the offenders who stole from them and damaged their property. They have to duke it out among themselves legally. And so, if Mr. Richards doesn't pay his share, you'll have to pay the full amount, and then you have to sue Mr. Richards to get, the amount he didn't pay. And again, those payments will be made through the Hiding County Victim Witness Office through their victim restitution escrow. You have to pay any service fee that's charged for that. I think it's still $5. Now, by being placed on community control rather than be sentenced to prison, you're deemed consented to serve without a warrant. Your person, residence, vehicles owned by you, used by you, or any other property places under your control where you're found at any time, any house within the probation department. Now, in the event that you're also ordered to pay the court costs as a subsequent order, and you're to make payment arrangements for those as well as a condition. And if you don't make those payments, then the clerk could collect that through various means, including lending on bank accounts, wages, earnings, or other assets you may have. That doesn't collect it upon completion, or then the court could order you to do the service and give you credit for each hour work. And an hourly rate set by the court each hour work and reduce your credit, apply that amount to pay the full that you serve in this county. Now, in the event that the probation department feels that you have failed to comply, then, and I forgot to mention that the convictions are for breaking and entering and theft, which is 3 felonies. In the event the probation feels that you have not complied, they will file written notice out of court. You'll be given a copy at the private hearing. If the outcome of that hearing is you have failed to comply, at that time the court can revoke your community control and then sentence you to 6 to 12 months in each charge, This could be served consecutively, so it could be a minimum of 6 and a maximum of 24 months for the 2 counts. There could be a fine of up to $5,000. If you are sentenced to prison and you serve a prison term, upon completion of the prison term, Mr. Ward, the adult parole authority could determine that you should be under post-release control supervision for a period of up to 2 years, which means that you would be supervised on the terms they set. And if during that period of time they found that you failed to comply, they could return you to prison and make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term, all violations. But if your violation is a felony, in addition to whatever sentence the judge in the new case imposed upon you, that is also authorized sentence. In this case, to an additional period of 1 year, whatever time left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the case. All right, is there anything further, counsel? All right, you're off of pretrial supervision, so you're no longer under house arrest, but you need to report down probation to be transferred over to felony supervision.
Yes, sir.
Thank you.
Thank you.
Thank you.
You're good to go, buddy.
All right, thank you.
Good luck, man.
Got anything for you?
No, just go around that way and
Okay.
report to probation.
Did they ever recover those photographs on camera?
No.
What did she do, destroy the phone?
I don't know what she did with the phone.
Well, I mean, she got another one.
Then she
That
chose
shows
to
like-
have you traded it in and destroyed it.
Those
Those weren't tears
They're
of
found.
Those weren't tears of, I'm sorry what I did.
Yeah.
Those were tears of, I'm sorry where I'm going.
YouTube's on, and we are on the record for Brock Vernon, Your Honor.
All right, are you Brock N. Vernon?
Yes, Your Honor.
All right, this is case number 22 CR 46, State of Ohio versus Brock N. Vernon. Mr. Vernon, you were indicted by the grand jury on March the 1st, yesterday, for escape and assault on a peace officer. The first count is escape, alleges that on or about January 18th of this year, in this county, while you were under detention, you purposely broke or attempted to break detention, and you will be held in connection with a felony, with a post-police control violation for assault on a peace officer out of Fayette County. And that would be violation 2921.34A1, which is a third-degree felony, and carries possible prison term conviction between 9 and 36 months, and a fine of $10,000. Count 2 alleges on or about January 18, 2022, in this county, you knowingly caused or attempted to cause harm to patrolman Warren Hamilton, a peace officer, while in the commission of his official duties. That's a fourth-degree felony, carries possible prison term of between 6 and 18 months, and a fine of $5,000. Now, you are entitled to have an attorney to represent you, and if you cannot afford to hire one, the court will appoint one for you. And I believe you filled out a financial disclosure form. Yeah, there it is. All right, indicates you have no income of any sort. Is that correct?
Yes, Your Honor.
All right. Court will find that you are entitled to appoint counsel or appoint attorney William Armentrout to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. So the bail review hearing for Friday morning, March the 4th at 8:30 a.m. Are you being held on any charges besides this right now?
No, Your Honor.
Okay.
Prosecutor sheet says an APA holder on it as well.
Yeah, okay, the APA has a holder.
That's what
Okay. I thought so. That's what was in there originally, okay. All right, your first pretrial then will be March the 16th at 1 o'clock. Or, I'm sorry, yeah, March the 16th at 1 o'clock, yeah. Final pretrial. Will be April the 7th at 1 o'clock. And your jury trial will be set for April 14th at 8 a.m. And that is short, because I'm not sure about the trial time. I think we probably have a lot more time than that, but since it's a whole week now, I'll just set it that way. It can always be continued if you and your attorney need more time. The court will set bail amount of $10,000 plus your owner cognizance, which is your promise to appear, to fail to appear. You could be prosecuted for an additional felony, and if convicted, sentenced on that, regardless of what happens in this case. You'll also be required to pay a service fee of $171 for certain statutory required fees prior to your release. If you make bond, you'll be under pretrial supervision of the probation department, 117 East Main Street. Report to them immediately upon release, and then you're required to report that once a week, 4 weeks, and after that, as they determine. Undergo random drug testing in my order, provide phone numbers for home, cell, employer. Have no contact with alleged victim. Recommend by probation to be evaluated for substance abuse and mental health issues, and triggers indicated to enroll in and call that for dependency of this action. And you also be under house arrest for residence. I'm having trouble reading that address. What is it?
26225 Locust Grove Road, New Holland, Ohio.
Locust Grove Road, okay. New Holland?
Yes, sir.
Alright, so you'll be there at all times unless you're working, going to and from work. Medical appointments, court proceedings, in this or any other case, appointment with an attorney, probation officer, in this or any other case. And any kind of educational programming, training, etc., or church services of that you have to be there at all times. If you fail to comply, then the court could revoke that bond and have you held to a court order. All right, we'll notify your attorney of the appointment, and he'll be at your hearing on Friday morning. You have any questions?
No, Your Honor.
All right, thank you.
Thank you.
All right, you're Adam Willie?
Yes, Your Honor.
All right, this is case number 22 CR 68, State of Ohio versus Adam Leon Willie. Willie is appearing by video from the Justice Center. Mr. Willie, you were indicted by the grand jury yesterday on a charge of failure to register a change of address as a registered sex offender. That is a third-degree felony. That if you're convicted, carries a possible penalty between 9 and 36 months, fine of $10,000, allegedly on or about January 1 this year. Thereafter, in this county, be a registered sex offender from this court, case number 15 CR 291. She failed to register provide notice of any change of address within 20 days, and been previously convicted of gross sexual imposition, having duties registered every 180 days. And you are entitled to have an attorney to represent you in this matter. I'll hire one for you. So you have without a financial I thought you did. Yeah, there is. All right. Is everything on this form we're looking at correct?
Yes, Your Honor.
All right. Court will appoint attorney Daniel Red of Hillsborough, Ohio, to represent you in behalf of the council that are not guilty plea on your behalf. Set a bail review hearing for Friday morning, the 4th, at 8:30 a.m. That'll be by Zoom. And so when were you arrested on this charge as well?
The paperwork's at 19th, Your Honor.
When?
The 19th.
Of February?
Yeah.
January. It says January on the prosecutor's sheet, January 19th.
Oh, January 19th, okay. All right, and let's see. Another 4/16. All right, so your first pre-trial is going to be set for March the 16th at 1 o'clock. And we'll set a final pre-trial for April. Are you being held on any other charges, by the way?
No, Your Honor.
Right. April 7th at 1 o'clock. And we will have your jury trial on April 14th bond will be set in the amount of $7,500 plus your own recognizance, which is your crime of repair, failure of care, could be prosecuted for additional felony and convicted, sentenced on that regard for acts in this case. You're required to pay a deposit of $171 for certain statutorily required fees prior to release. The other three trials will be with the probation department in Maycon, at 117 East Main Street. Report to them immediately after your release. Report to them once a week for 4 weeks after that is they determined. They go random drug testing that they order, provide phone numbers for home, self-employer. If recommended by probation, evaluate substitution of health issues and treatment indicated, enroll in all that. Recommends this action will be under house arrest for residence, 40 years form is 137 West Pleasant Street, Hillsborough. And you have to do it at all times, unless you're working, going to a front work, medical appointment, court proceedings, is there any other case, appointment with an attorney or probation officer, is there any other case other than that? You have to do it at all times, if you don't apply, then the court could revoke that law, and that's the first word. Have any questions, Mr. Welling?
No, Your Honor.
All right, thanks. All right, are you Natasha Nelson?
Yes, sir.
All right, this is case number 19 CR 139. They will have Ms. Natasha Nelson. And Ms. Nelson put on community control on December 19th of 2019. In charge of forgery of fifth-degree felony. The
Yes, sir.
probation department has filed an application alleging that you have failed to comply with the terms of your community control. Alleges that you violated Rule 2, that on February 22nd of this year you failed to report. Rule 7, that on or before March 1st you tested positive for fentanyl, cocaine, and THC when you were administered a drug test at the jail. Rule 15,
Yes.
you still owe $462.50 court cost. And Rule 19, you failed to pay $800 in restitution, still owe. Alright, now, you're entitled to have a hearing in this matter, and entitled to be represented by an attorney. Did you fill out a financial disclosure form?
Yes, sir.
You did?
Yes.
Okay. Oh, here it is. Alright, everything on this correct?
Yes.
Alright. Court will appoint attorney Sarah Barber to represent you. Will be in bond. And we'll set this matter for an evidentiary hearing.
Okay.
On March the 17th. At 1 p.m. I'll notify your attorney of your appointment. And you can get her number there to jail if you need to get in touch with her. All right? Thank you.
Yep.
Thank you, Your Honor.
There you go.